Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Honorable Supreme Court of India, 2 judges bench, Justice P.S. Narasimha, Pamidi Sri Narasimha, and Sandeep Mehta. In the case of Satyadev Singh versus State of UP and others, SLP number 29758 by 2018, yesterday, that is on 18/11/2024, held that, this is very important, recording of evidence, recording of the statements is necessary even in disciplinary proceedings where major penalty is proposed. For the government sovereigns, under CCA rules, that is Code of Conduct and Appeal rules. Of course, these rules vary from state to state, but according to these rules, the disciplinary proceedings, there are two types of punishments, minor punishments and major punishment. Minor punishments are like giving a warning, like censure, CENSURE, withholding of increments without future effect. This is one part. Whereas major punishments, they are reducing the time scale of pay, reducing the promotion scale, removal, dismissal, all these things, they come under the major punishments. Because the institute or the government has to run properly, these rules are framed. I will give a simple example. ఏ అనేవాడు బి అనేవాడిని కొట్టాడు అనుకోండి, బి అనేవాడు ఏం చేస్తాడు, పోయి వాళ్ళ నాన్న ఎవరిని తీసుకొచ్చి నలుగురు అంతాడు. ఏ అనే గుమస్తా బి అనే ఆఫీసర్ని చెప్పు తీసుకుని కొట్టాడు అనుకోండి, బి ఏం చేస్తాడు, తిరిగి కొడతాడా? కొట్టడు. బి విల్ కంప్లైన్, బి విల్ గివ్ ఎ రిపోర్ట్, ది అదర్ ఆఫీసర్ will make an enquiry, then this man will be suspended or dismissed or removed from service because it is a procedure. దానికోసం కోడ్ ఆఫ్ కాండక్ట్, అప్పీలు, డిసిప్లిన్, రూల్స్, ప్రొసీజరు ఫాలో అవ్వాలి గవర్నమెంట్ సర్వీస్లో కంపల్సరీ. ఓకే, ఇక ఈ కేసు పై వచ్చేటప్పటికే ప్లీజ్ రిమెంబర్, సుప్రీంకోర్టు చాలాసార్లు చెప్పింది. ఈ కేసు ఒకసారి ఫ్యాక్ట్స్ చూద్దాం. దిస్ మ్యాన్ వాజ్ వర్కింగ్ యాజ్ సమ్ అసిస్టెంట్ కమిషనర్ కమర్షియల్ ట్యాక్సెస్. ఇప్పుడు జిఎస్టీ వచ్చినాక అంతా ఒకటి అయిపోయింది. గతంలో కమర్షియల్ ట్యాక్సెస్ ఏపీ స్టేట్, ఏ స్టేట్ కింద ఆ స్టేట్ కమర్షియల్ ట్యాక్సెస్ డిపార్ట్మెంట్ ఉండేది. సో సమ్ అలిగేషన్స్ వర్ దేర్ అగెన్స్ట్ హిమ్. సో దేర్ ఫోర్ సత్యదేవ్ సింగ్, సో an enquiry was forced actually to be dismissed basing on the allegations which are proved. ఏంటి డిస్మిస్సల్ దగ్గర అమౌంట్ అయ్యి ఉన్నాడు, బట్ వాట్ ఎవర్ ఇట్ ఈస్. 5/3/2012 నాడు చార్జ్ షీట్ వాజ్ ఇష్యూడ్ హిమ్. అంటే ఏంటి, అతని మీద అలిగేషన్స్ ఒక ప్రొఫార్మా చార్జ్ షీట్ లాగా తయారు చేసి చార్జెస్ వర్ ఫ్రేమ్డ్ అగెన్స్ట్ హిమ్ అండ్ హీ వాజ్ ఆస్క్డ్ టు అపియర్ ఫర్ ద ఎంక్వైరీ. అండ్ ది ఎంక్వైరీ is completed by 29/11/2012. That is almost 8 months. 8 months later, the IO submitted the report. Right. Here, the punishment was censure plus stoppage of 2 increments with cumulative effect. With effect means very, very dangerous. You may be under the impression, what happens if it is for 2 or 3 years? Suppose if the increment is around 1,000 rupees, yearly 12,000 rupees, cumulative next year 24, 36, and this 36, if accrued till the retirement service, a lot of money will be lost. Right. But when he approached the UP Services Administrative Tribunal, they quashed the order because there are no recorded evidence. There is no recorded evidence. This is the main problem. The enquiry officer did not record the statements of any person. Here, this Satyadev Singh clearly approached the tribunal also stating that no evidence was recorded. Even oral evidence was also not recorded. Okay. Then the government approached the High Court. High Court actually quashed or set aside the orders of the tribunal, and they said the original orders are, the IO report is 100% correct, let him be suffer with the so-called cut in the increments. Against this, he has approached the Supreme Court. Now, the Supreme Court clearly stated that no witnesses were inquired during the enquiry. Even the oral evidence was also not recorded. According to rule number 7, sub-rule 3 of UP Government Servant, within brackets, Discipline and Appeal Rules 1999. This rule number 7, mandates the recording of oral evidence, more particularly in major penalty cases, which was not done. So, procedural lacunae. So, Honorable Supreme Court of India, basing on two important cases, that is Roop Singh Negi, I think I have given my videos also, versus Punjab National Bank, 2009. Second is Nirmala J. Jhala versus State of Gujarat, 2013. Basing on this, Supreme Court held that even ex parte enquiry also, it is sine qua non. It is sine qua non. That is needless to say. To record evidence of witnesses for proving the charges. So the Supreme Court, in catena of cases, held that recording of evidence in disciplinary proceedings is a must, particularly in the so-called major penalties is mandatory. If you fail, then advantage will go to the so-called authority, that is Assistant Sales Tax Officer, Satyadev Singh. So, ఒకసారి Supreme Court చెప్పినాక ఎవరైనా చేయలేరుగా. This is the judgment given by the Supreme Court in the service matters. If at all anybody is doing it, you can mention it also. Thank you.